Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of Kentucky versus Grimes, 835F.3D570, Court of Appeals, 6th Circuit, 2016. Friends, today we have an example of coalition building to inspire us. So let's get inspired. This case involves the Libertarian Party joining forces with the Constitution Party. I love to see third-party coalitions. They fought here to challenge the ballot access laws of Kentucky. What happened, friends? What happened? Let's read from the record. It says, quote, "Appellants are the Libertarian Party of Kentucky, the Libertarian National Committee, the Constitution Party of Kentucky, and Ken Mollman, Jr., an individual voter and former Libertarian Party candidate for Kentucky state office. The gravamen of appellants' complaint is that Kentucky law unconstitutionally burdens appellants' First and 14th Amendment rights to freedom of political association and equal protection by categorizing the Libertarian Party and the Constitution Party as political groups, which must petition to list their candidates for state and local office on election ballots rather than as political parties or political organizations which enjoy blanket ballot access for all the candidates they nominate. The district court concluded that the Commonwealth of Kentucky's three-tiered ballot access scheme was a constitutional means of exercising the Commonwealth's power to regulate elections." End quote. Let's think about this. First, I wonder, what does gravamen mean? That's not a word I use every day. Maybe you do. Judges here are using it. So what does it mean, friends? Once again, they're invoking our beloved First Amendment and also another great amendment, the 14th Amendment. Again and again in these ballot access trials, I'm seeing that. The First and 14th Amendment. We here at Free Press Media Press, Inc. love third parties and the First Amendment, and when you combine the two, you get political glory squared, cubed, galore. Once again, this is also a different structure than some of these other states. As they continue, it says, quote, "The Commonwealth of Kentucky classifies a political association as a political party if it received at least 20% of the total vote cast in the last presidential election, a political organization if it received at least 2% of the vote of the state in the last presidential election, or 3, a political group if it fails to qualify as a political party or a political organization." End quote. How do you like that way of framing things? How do you like that, friends? Do you think that's good? Is it advantageous to our side? I haven't seen anything like that before. Maybe you have. They also say, quote, "Members of a political group, on the other hand, must obtain voters' signature on a qualifying petition in order to gain ballot access. The signature requirement is 5,000 for statewide office, 400 for the United States House of Representatives, 100 for county officer, member of Kentucky General Assembly or the Commonwealth's attorney, and 25 or fewer for various other local offices." End quote. Do you think those numbers are fair, friends? Do you think we should have ballot access laws at all? If not, what should be the way to get on the ballot? They say again and again, in this case as well as other cases, we need the ballot access laws to prevent all these every candidate and their mother from being on the ballot. So if there's any validity in that, how do we counter that argument? How do we counter that? What do we want as an alternative? The Libertarian Party and the Constitution Party here argue that 2% is too much. They say it's too high for them to reach. They say it costs a lot to get petitions, and therefore they're going to pay a lot to do this. This court mentions in a prior decision that 5,000 signatures is not too high, and it doesn't violate the 14th Amendment. They say here they haven't yet addressed whether 2% is in violation of the First and 14th Amendment. This case, like I said before, is an example of coalition building. So let us applaud the Libertarian Party and the Constitution Party of Kentucky for getting together. Whatever differences they may have between each other, they join in common cause. So we love that. They say here the 2% issue isn't that bad because there's other ways to get on the ballot, such as the petitions. What do you think about that? Do you think that's right of the court to say that? They also argue that the Libertarian Party and the Constitution Party here have an invalid argument in suggesting it's too high a requirement. They say other third parties have done that in the past, so they can do that too. They also go on to say that the cost is not an issue either because the way they figure the cost, which would be in some cases in the six figures, it was what would charge by the agencies that get petitions rather than the cost the parties would incur by doing it themselves. How much are petitions, how much does it cost to sign to gather the whole petitioning process? From your experiences, let me know. I've gathered signatures before for a local office, and I've helped the Reform Party get signatures for their offices, so I have some experience, yet I'm not entirely sure what would be a good figure for the cost. Here, guess what they do? They cite the 2000 election for a reason that we can't have lower access requirements. They say the reason Florida was in the mess it was in 2000 was because they had 10 parties on the ballot. And that caused ballots to have to be designed in odd ways. That, to me, friends, is a ridiculous argument. No, no, no. More access on the ballot doesn't necessarily have to lead to crazy ballots. It doesn't necessarily follow. Also, even if it does lead to crazy ballots, wouldn't it be still right? They're saying here that ballot access requirements prevent 10 parties being on the ballot. But what if 10, 20, 30 parties succeeded at the ballot access requirements? You still have the ballots with all the different parties. So this argument is not good, friends. The Libertarian Party and the Constitution Party propose something interesting. They say instead of having to gather signatures for each individual office, you could have one signature gathering. That sounds good to me. What does it sound like to you? Unfortunately, the judges here said no. That may or may not be true, they argue, but we have to stick with what Kentucky has. So ultimately, they said this, quote, accordingly, the district court's judgment is affirmed, end quote. congratulations to the Libertarian Party and the Constitution Party for minimizing the differences you have and joining in common cause to fight ballot access laws so third parties can get a fair shake. May this and other cases inspire us to find ways to get more third parties on the ballot. Long live third parties. Goodbye.